Welcome everyone to another question and answer session live. My name is Samara Belitzky and I am an employment lawyer at Samfiru Tumarkin. I'm working out of our office in Ottawa, but I'm here today to answer all of your questions about employment law, regardless of what province you're in, regardless of what city you're in. Send in your questions. I'm here for the next half hour or so to answer all of your questions about severance, workplace issues, health and safety, COVID-related issues that are still ongoing, whether it be vaccines, masking, whatever the case may be. We're still getting a lot of questions about that. Like I said before, severance, changes to your workplace terms and conditions, whatever the issue is, I'm here to answer your questions. So send in your questions and I'm more than happy to answer them. Something that's kind of come up very recently, a couple of things that have been in the news, especially today, is the QP strike with respect to the teachers union in Ontario. So that's something that, we've been getting a lot of questions about. And I was going to talk about that if we're not getting questions in, but we already have questions coming in. So I have that I wanted to discuss because we have so many questions about that issue. And then we also have lots of questions coming in about this mass layoff from Twitter. So if you haven't heard, Twitter is laying off reportedly 75 or 50% at least of their workforce. Now, it remains to be seen how many people actually are being let go, but that's what's being reported. We've actually, here in Canada, although a lot of the workers are in the US, there are some in Canada, and we've already heard from people who have been affected by these layoffs, or I should say terminations, because that really is the proper term for it. And so if you are somebody who's been affected by this, if you work for Twitter and you're in Canada and you've been affected by this, definitely get in touch with us. What's really, really important to know whenever we're dealing with these situations, whether it's a mass layoff like the one that we're dealing with Twitter right now, we've had other ones recently. For example, Shopify did a mass layoff recently. We've had a lot of them actually in the tech industry in the last few months. But what's really important to keep in mind, whether it's a mass layoff and you're one of 200 people, 2,000 people, or you're the only one being laid off or being terminated, it's very important to make sure that whatever is being offered to you, you get reviewed by an employment lawyer first. Get in touch with us and somebody will be able to review your package for you, review your offer, and let you know where you stand. It's so important to do that before you accept or sign anything. Because once you sign, that's it. You're stuck with it, and there's nothing you can do about it. And 9 times out of 10, if not 10 times out of 10, the employer is not going to offer as much as they should. They're going to offer less and see if they can get away with it, see if the employee will accept what they're offering without going to a lawyer, whatever the case may be, and just accept it. Don't do that. Make sure you get it reviewed, and we're more than happy to do that for you. So get in touch with us. You can always email us at help@employmentlawyer.ca. You can go to our website, which is employmentlawyer.ca, and contact us that way. But certainly do not just sign on that dotted line without getting it reviewed by a lawyer first, because the odds are you'll be owed much more than what you're being offered. In terms of the Twitter layoff, as I mentioned before, there are a lot of people being let go. There are certain provisions in Canada from province to province, it's different, but similar, in that if there is a mass layoff, your minimum entitlements under your provincial employment standards legislation will be higher if it's part of a mass layoff. But that's just your minimum. That's just your starting off point. So generally speaking, if it's part of a mass layoff, a mass termination, your severance will be more, as a bare minimum, will be more than if it was just you or, a few other people being let go. But that's just the starting off point. You will be entitled to more than that in most situations. And so it's really important to get that reviewed. Oftentimes when it is a mass layoff, what we see very, very frequently is employers offering only the bare minimum because they're trying to save money. Makes sense as an employer. If you're going through a restructuring and you're laying off lots and lots of people, part of a mass layoff, it's likely because of financial reasons. And so it makes sense that an employer would offer you just the bare minimum, offer the bare minimum entitlements, the bare minimum severance or termination pay, and that's it, and nothing more than that. But again, most of the time you will be owed much, much more than that. So it's up to you as the employee to do your due diligence, get in touch with us, have an employment lawyer review your package, make sure you're getting what you should before you sign anything. So we're getting a lot of questions come in. I'm going to get to the questions, and then if we have time to talk about the QP strike, we certainly will. So I'm just going to scroll down here to the questions. I have a question from Alex on Facebook who says, I got terminated with cause. Am I entitled for severance pay? Great question. So that will depend on whether the employer actually had cause to terminate your employment or not. Most often than not, when we're dealing with people who have been let go for cause, the employer did not actually have cause. So this is a measure that a lot of employers will implement. They'll say that it's a cause termination and that they don't owe you any severance when really they do. So it's especially crucial in situations where the employer is saying, we had cause, you've engaged in misconduct, or your performance is not up to our standards, we're letting you go for cause, you're not owed anything. It's especially important in those situations to get in touch with us and have us review your situation. You need an employment lawyer to review the ins and outs of the entire situation to be able to tell you whether or not the employer actually had cause or not. 9 times out of 10, they did not have cause. 9 times out of 10, the person who was let go for cause will be owed their full severance. And so it's really, really important to get everything reviewed by an employment lawyer. So to answer your question, Alex, it depends on the situation. So certainly you should be getting in touch with us to have us review your situation, figure out what happened. And then once we have all of the details, we can review that and let you know whether they had cause or not. My money is on no, they didn't have cause, because most of the time they don't. A termination for cause is a very, very high threshold that the employer needs to meet from a legal perspective. So when we're talking about terminations for cause or cause terminations, the burden is actually on the employer to prove that they had cause. And the like I said, the threshold is very, very high. So in terms of proving it, it's very difficult. And they have to actually prove that the employee engaged in serious misconduct and willful misconduct. So to give you very extreme examples, generally speaking, if somebody stole from the company, if somebody assaulted another employee, if somebody committed time theft, for example, those are situations that would amount to cause for termination, because that is serious willful misconduct. And the employer would be in their rights to end the employment relationship because the trust is gone and not give you any severance. Now, short of those extreme examples, the situations are always nuanced, and there usually would have to be what's called a progression of discipline if there is misconduct on the part of the employee. So if there's a situation where there's one incident of very severe misconduct, that could be a termination for cause. Otherwise, if it's you're late for work, there's absenteeism, you're not showing up for work, you're late for work, you're not meeting the performance expectations of your boss. Those are situations that require progressive discipline, meaning an employer has to warn you, the employee, listen, this is a problem, this is not okay, this needs to improve. If it doesn't improve, it can result in a termination for cause. And there has to be multiple warnings, and there has to be a progression of those warnings. Maybe it's a verbal warning, then it's a written warning, then it's a suspension, then maybe it's a termination. But they cannot just terminate you out of the blue without any warning for these kind of what I would call less severe instances of possible misconduct. So most of the time when I speak to people who've been let go for cause, there was no cause. A lot of the times we are dealing with performance issues where out of the blue, somebody's told, I actually just had this happen the other day. I was speaking to somebody who was given a warning 1 month before their termination. 1 month before that, for the first time in several years of employment, they are not meeting expectations and their performance needs to improve. 1 month later, they were told their performance hasn't improved enough, and so they're terminated for cause. That's not a cause termination. The performance has to be given enough time to improve, and the employer has to work with the employee in order to assist in that improvement potentially happening. If it doesn't work out, if there is no improvement after a very long time of giving that employee the opportunity, then it could potentially result in a termination for cause. I say could because even in that situation, again, that threshold, very, very high. There's a reason that we refer to it as the capital punishment of employment law, because the employee really has to have done something really terrible for that to apply. So Alex, get in touch with us. If you're in a situation where you've been let go for cause, or you know somebody who has been, again, get in touch with us. More than happy to review the situation for you and let you know where you stand. And if in fact it wasn't a termination for cause and you're owed your severance, we can assist you in going after your full severance. So it's very, very important not to just let it sit there. Get the advice from an employment lawyer that you need and move forward on pursuing your severance in the situations where severance is owed. So I'm going to continue moving on here in my questions. I have a question from YouTube from JBK, who says, if I work in a daycare located in a school and they close for a strike, does my employer have to pay me for being off? That's a very good question. So in terms of the daycare being closed, if you yourself are part of the union, because there are a lot of daycare workers who are part of the union that is striking, and you are striking, then you wouldn't be entitled to pay while you're striking, because especially right now, the strike from a purely legal perspective is technically illegal. And so there wouldn't be any pay for striking in that situation or for not showing up to work. So if that's the case, then no. If the daycare, if you're not part of the union, which if you're located in a school that's affected by the strike, you likely are part of that union. But if for some reason you're not and you happen to fall into kind of an exception or a carve out of that, if the daycare closes of their own volition, they don't have to close, but they're closing anyway, then you would be entitled to be paid because the employer is the one that's preventing you from working. So as long as it's a situation where it's actually the employer who's preventing you from working, in most situations, you would be entitled to be paid. If it's not the employer, so if, for example, the daycare is being forced to shut down by the union, if they're being forced to shut down because maybe there's a picket line and you actually can't get to work and they have to close, those are situations that can be argued are outside of the employer's control, and they might be able to rely on that to say that you're not entitled to be paid because you didn't work that day due to no fault of their own, but due to external factors. So that is something that I could see coming up as an issue, but it does depend on the situation. So depending on your specific situation, if like I said before, if it's them just saying don't come into work because we're just choosing to close, even though they don't have to, you should be paid for that. And if you're not, definitely get in touch with us. We can assist you with that. And if you're not unionized, you can probably go to the Ministry of Labor for that issue if it's just unpaid wages, only unpaid wages, nothing else. Otherwise, if you are unionized, you should be speaking to your union about that. I have a question on Facebook from Sarah who asks, if I'm not laid off but offered a job at less pay, can I refuse? The short answer is yes, but it does depend on the circumstances. So generally speaking, your employer does not have the right to cut your compensation, to reduce your compensation without your consent. They would need your consent and your agreement to do that. And if they don't have it, they're not allowed to do it. Now, the caveat there is when we're talking about these types of reductions, they have to be significant. So if the reduction in pay is, for example, only 5%, unfortunately, that's a situation where you wouldn't necessarily be able to push back too hard, because from a legal perspective, the reduction in pay would have to be about 10% or more in order for it to be considered a significant change. And then you would be able to refuse it. And if the employer forces it on you, even though you've refused it, you do have the option to consider it a termination of your employment, a constructive dismissal, and go after your full severance. So it's really important to get legal advice on this issue, Sarah, because depending on the situation, what the reduction is, how it's being imposed on you, you need to proceed very carefully to make sure that you're in the strongest legal position possible to deal with this issue. You might very well be in a situation of a constructive dismissal, meaning your employer is not firing you outright. Like you said, you're not laid off, but the result is basically the same, because if, let's say, they're going to reduce your pay by 30%, obviously you can't keep working because you're not going to be able to pay your bills with 30% less pay, right? So you wouldn't agree to that change. And if they impose it on you, you basically have no choice but to consider that your employment's done, you've been terminated, and go after your severance. So it really does depend on what that percentage might be of the overall pay reduction that's being imposed upon you. And on top of that, you have to be careful in making sure that you don't agree to it. So if it is a significant change, you have to express that you do not agree to it, and you should always be doing that in writing. Whenever you're going to refuse a change, it has to be done in writing, because you have to protect yourself and have a record of it that you can rely on later on. So in this situation, that's what I would recommend that you do, but it's important to get advice from a lawyer first to make sure you don't do anything that's going to potentially harm base here to pursue your severance. So you want to make sure that you do everything you can to be in a strong legal position. I assist people with things like this all the time in terms of dealing with workplace changes, refusing them, and there are very specific steps that need to be followed to make sure that you end up being successful in being able to go after what you should be owed, which is your severance pay, if the employer will not back off. If they will not back off and they're going to force that change on you, you're owed your severance. So definitely get in touch with us, Sarah. If you want to email me directly, feel free. My email address is on our website, employmentlawyer.ca. You can just click on my profile and send me an email, and I'm more than happy to look at this with you and see what we can do to help you. So I have a question here from Jay on YouTube, who says, in one of my jobs, a lot of us feel the employer has created an unsafe work environment. Some have quit. If you leave what you feel is an unsafe work environment, would severance be owed? It depends how you do it, Jay. So in a situation where you feel like you're being asked to do unsafe work, you have the ability and the right to refuse unsafe work. And the employer then has to investigate, okay, what is it that you're saying is unsafe? And they can't force you to do unsafe work. The employer should also be bringing in the Ministry of Labor to investigate that issue as well, if you really have made an unsafe work complaint. If the employer does nothing, if they tell you they're going to fire you if you don't do the unsafe work, if they treat you negatively because you've refused to do unsafe work, there are things you can do about that. There are complaints that you can file with the Ministry of Labor. There are lots of things you can do about that, including working with a lawyer on a potential constructive dismissal claim. Now, if a workplace becomes so unsafe or so toxic to the point where you feel like you can't work there anymore, you need to get advice from an employment lawyer before you do anything. If you quit and then you, let's say, contact a lawyer months later, there isn't likely anything that we're going to be able to do for you. And unfortunately, I have to have this conversation with people sometimes where they contact us, maybe it's a year after everything has happened. It's very, very hard for us to assist you after the fact. So it is so important that you contact us while these things are going on. Get in touch with an employment lawyer while these issues are happening so that we can advise you on how to deal with them, how to make sure you have a strong case, what to do next. And that way, when the time comes where you can do something about it, you're ready to go and you're in a strong position. If you just deal with it on your own, you don't follow the proper process, which would include filing a complaint, whether it's an unsafe work environment, a toxic workplace because of bullying or harassment, whatever the case may be, usually your first step there would be filing an internal complaint and triggering the employer's obligation to investigate that and make sure that they're making whatever changes need to be made so that it's not a toxic or unsafe workplace. If they fail to do that, then the next step would be to involve a lawyer. So there are options that you have, but you have to be doing it in real time as these things are happening. If you don't do that, and then you feel like, you've had enough, you've been dealing with this for long enough, and then you just resign and you quit, again, there's going to be very, very little that we can do for you at that time. You may very well be in a situation where it's an untenable work situation, it's unsafe, it's toxic, what have you, and you might have the right to actually resign and claim constructive dismissal, meaning it's become so bad at work that you just can't continue to work there. You have no choice but to quit. Well, in that situation, even though technically you're quitting, at law, it's actually a termination because the employer has made it so that you have no choice but to quit. So in some situations, that would be available to you. In that situation where that could be available, where it's so bad that you have no choice but to quit, from a legal perspective, if your situation meets that threshold, then you would be considered to be constructively dismissed and you can go after your full severance. So in terms of your question, there are some situations where you can leave an unsafe work environment and go after severance and claim that you've been constructively dismissed, but it does depend on the situation. Not every situation will provide that recourse, will entitle you to severance. It depends on what's going on in the workplace. What have you done? Have you brought it to the employer's attention? Have they done anything about it? All of these things are what we look at when we do the legal analysis. So every situation is different, and that's why it's so important to get legal advice as soon as these things start happening. Because if you act without legal advice, and then you quit and you don't do anything else about it, and then you contact us, again, very, very little that we could do for you. There are certain situations that are exceptional. So, for example, I've assisted someone before where they were actually punched in the face at work on the spot, punched in the face, and they immediately quit and walked off the job. In that situation, we were able to assist that person because they contacted us right away, right after that happened, and we were able to assist them, especially given the very extreme situation. But most situations, when we're dealing with, toxic workplaces or unsafe workplaces, they're not as black and white. It's usually more in the gray, where you're dealing with a bunch of different issues that have happened over a period of time of several weeks or several months, and there are various steps that you can take. So those are the situations where you really have to contact a lawyer before you act to make sure you're in the best position possible. And again, in certain situations, you absolutely could be entitled to severance pay. Okay, so I have a question from Martin on YouTube who says, can my employer refuse to allow a temporary shift change to help with childcare? So great question. Thank you, Martin. This is a question we've been getting a lot, especially with this strike happening now, where they've closed down a lot of the schools. And as parents, if you're working with children, you're kind of stuck now in terms of trying to find alternate childcare arrangements. So what's really important to know in this situation is that there is an obligation for an employer to accommodate in very narrow circumstances. So there is protection under the Ontario Human Rights Code, and in other provinces as well, there's similar legislation that outlines that there's a protection for family status. So if you have childcare obligations and you have absolutely no alternatives in terms of childcare, then your employer does have to accommodate you as long as they can, as long as it's possible. Now, when I say, there are no other alternatives, that means you have no family, you have no friends, you have no neighbors, you can't get them into another daycare that is open. There's just absolutely no alternative whatsoever. You've tried everything, you've contacted people, you've contacted other daycares, you've done everything you possibly can to prevent you from having to request this accommodation, but it's just not something that's going to be possible. At that point, then your employer would have to accommodate you, again, as long as it's possible. And when I say possible, the kind of magic words that you often hear are undue hardship. So they have to accommodate you up to a point of undue hardship. What does that mean? It doesn't mean that if it's inconvenient, they don't have to accommodate you. Accommodations are inconvenient for the employer. That's a given. So it's not just if it's inconvenient. It has to be beyond inconvenient. It has to be extremely expensive to the point that it's not doable or just impossible whatsoever. So if, let's say, you work 9 to 5 and there's no shift work, then those are your hours. There might not be a way to work other hours if there isn't another shift. If there's a night shift and a day shift, then you have the ability to potentially work the night shift and then have your childcare during the day. And the employer can shift the schedule around with maybe some of the workers who don't have kids until this strike is over, which would obviously be a temporary thing because the strike is not going to go on forever. And so in that situation, there would be an accommodation. So no, your employer can't refuse it as long as I said before, you've exhausted all other options and there is an accommodation that could be available to you that's possible for the employer to implement and that doesn't cause them undue hardship. Okay, so that's generally what you need to keep in mind. Anyone who's dealing with this issue right now, and I know that going into next week with this strike, a lot of people are going to come into this issue of, what do I do with my kids during the day? I'm supposed to be at work. They're usually at school or daycare, but the school and the daycare is closed. So we're getting a lot of this question, and that's what you have to do. Exhaust all options. And if you do, then you can go to your employer for an accommodation and approach it from a collaborative perspective. Most employers will understand that this is not a situation that anybody wants. It's a situation that's created by the strike. And so, there should be that cooperation between the employer and the employee to try and figure out a way to make this work while this situation is happening. And again, it's temporary. So most employers should be able to figure something out here. I have a question from Latoya on YouTube. Who says, if you report being threatened, bodily harm, and being bullied, and you feel unsafe and beg someone to step in because you are a female and these are males and they do nothing, I was suspended and fired. Okay. So a few things to unpack here, Latoya. Obviously, if you're being threatened with bodily harm, that's not just an issue in employment, that's also a criminal act. So if that's the case, then you may want to be looking into filing a police report for that. Of course, filing if anyone's in that situation, of course, you're going to file a complaint with your employer, make sure it's always in writing. But, this kind of goes beyond what we would see regularly in terms of bullying and harassment. This is, criminal behavior. And so you may want to file a police report in that scenario. If you feel unsafe at work, you should be filing a complaint. Absolutely. So anytime you feel unsafe at work, as we touched on before, whether it's, you're being asked to do something that you feel is unsafe, or somebody is treating you in a disrespectful and unacceptable manner, your first line of combat here in terms of what to do, your line of attack is to file an internal complaint, and you always have to do it in writing. Now, as I mentioned before, it's very good to get legal advice from an employment lawyer. That's what you should be doing. But if you're not going to do that, then absolutely you should be filing a complaint. The employer then has an obligation to investigate. Here, it looks like you may have filed a complaint, nothing was done, and then you were let go. So if that's the case, that would be unlawful because you're not allowed to be let go for filing a complaint. If you feel like you're in an unsafe work environment and you file a complaint for bullying or harassment, the employer is not allowed to let you go because of that. Even if it turns out that you thought you were being bullied, you felt like you were being harassed, but maybe at law it doesn't quite meet that legal definition of harassment. So there's an investigation and they find that your allegations were unfounded. Even if that happens, you still as an employee are protected. The employer does not have the right to commit reprisal, meaning treat you in a negative manner, meaning either they discipline you or they fire you or they just treat you negatively because of you filing that complaint and enforcing your rights. They're not allowed to do that. So in this situation, there's a few things at play here for you, Latoya. They obviously didn't do what they were supposed to after you brought this issue to their attention. So they continued to foster an unsafe workplace. And then not only did they not do anything to assist you and make sure the workplace was safe, they also fired you because of it, which they can't do. So that's an issue. And then, of course, you'd be owed your severance on top of that. You'd be owed your full severance. Other issues at play, depending on, what went on here, would be a potential human rights claim. And you may be owed human rights damages for this as well if it was because you were female, because they are not allowed to discriminate against you on the basis of your gender. Okay, so a few issues at play here, but certainly not a situation where the employer has done what they were supposed to, and you're definitely owed damages and severance here. So I see here you're saying you've contacted an attorney. That's the right thing to do. That's great. You can contact us as well if you wanted to get legal advice from us on your situation or assistance from us. But no matter whether you contact us or another lawyer, the important thing here is you pursue this, because this is not right, and it needs to be dealt with, addressed, and I'd say made as right as possible in terms of getting you what you're owed. Nothing can ever take back the way that you were treated, unfortunately. No amount of money can do that, but at least you should be owed, you're owed, and you should get what you're owed in terms of your severance and your damages. So don't back down on that. Definitely pursue that. And if anybody watching is in that situation, a similar situation, again, don't be intimidated. Don't back down from these situations. This is what we're here for. We're here to help people in situations like this. And certainly you are not alone, and you should get in touch with us if this is a situation that you're in. So with that, we're at the end of our session for today. I know there's a few questions I didn't get to. We had a lot of questions today. So if we didn't get to you, feel free to send your question to help@employmentlawyer.ca. Otherwise, you can tune into our next session next week. We have them several times during the week, so keep an eye out, and you can always send your question in to the next session. All right. Thank you, everyone, very much for tuning in, and I hope everyone has a wonderful weekend.